So my name is Miranda Bogan. I'm the director of the AI Governance Lab at CDT, and I'll be moderating today, but my team also works on this topic, so I'll be dipping in and out of the conversation as well. But just to level set in the room, can I ask how many people were following the story last week of Claudebot, Moltbook, OpenClaw? Okay, like a little more than half, but tentatively. So panelists, take note. So in the last panel in this room, we were talking about interactions with chatbots, mental health harms, things like that. What has interested me about AI agents or systems that are maybe taking a little bit more action than just interacting with people is the fact that we're swinging back around from conversations about automated decision making a few years ago to really content focused harms in the earlier days of generative AI, and maybe now back to systems that are actually taking some kind of action or making some type of decision. But the boundary is really murky. We have search agents that are just surfacing information. We have agents that are orchestrating other actions and all sorts of other things. And so I think as a foundational question, and to get started, I wanted to turn to Helen. I won't introduce all the panels, but feel free to give a brief note of introduction when I turn to you. Helen, can you help us orient to what are AI agents? What are they today? And what are they maybe going to be tomorrow? And how do you think about the trajectory of these systems and how people's understanding of the way their actions and their maybe impacts and harms might play out? Help us sort of ground the conversation.
Thank you, Miranda. And by way of introduction, I'm the non-lawyer on this panel, so it's about liability. I really don't know much about liability. I know little bits and pieces, just enough to get myself in trouble. But yes, I work at CSET, Center for Security and Emerging Technology at Georgetown, where I lead a team of 50 focused on emerging tech and security. So really kind of safety and security, national security issues are my focus. So agents, I'm a language nerd. I come back to high school Latin classes. The word agent comes from agere in Latin, which means to act, to do. So basically, what's an AI agent? It's an AI system that does something. And what we're seeing these days is, in some ways, you could call a thermostat a computer that does something because it notices what the temperature is and then acts, so to speak. But what we're seeing, and the reason we're having more and more conversations about AI agents, is that we're getting AI systems that can carry out more complicated actions, fulfill more complicated goals in more complex open-ended settings. And they can do so in a way that is adaptable. They try something, it doesn't work, they try something else. So Miranda, I was actually going to ask the exact same question of who here is following the kind of Moltbook, Moltbot, OpenClaw story, because I think like in general right now, we're living in a time where a lot of hypothetical abstract ideas about what AI might do at some point in theory are starting to play out in practice. And reality is always stranger than what we could imagine. But what we're seeing these days is that AI agents have gone from a few years ago, when we had very simple agents that could maybe play a video game or maybe operate a simple robot. We now have large language models being hooked up with pretty simple software setups that let the large language model go out there, do things on the internet, carry out tasks for their user. And so what we saw the last couple weeks was Claude Code, which is a relatively recent product from Anthropic, getting hooked up with an open source scaffold or framework around it that was originally called Claudebot, then Moltbot, now OpenClaw, which let users basically task it to do all kinds of things that they might use their computer for. So it could go out and look stuff up on the internet, sure, but it could also do things with their calendar, order things for them, message with their friends and family, and more recently start posting on an AI agent social network called Moltbook, which is maybe beside the point for this panel, but very fun story there. So the basic idea here is AI agents today are starting to be able to do things both on the internet, potentially the open internet, as well as on users' computers. So you can use an AI agent to, for example, build a financial model for you. A lot of people in the tech world are using AI agents to write code, to edit code, to push changes to production systems. So right now, we're starting to see these early signs of AI that can do tasks. One thing I think was helpful about Moltbook, this sort of social network for agents that ended up having millions of AI agents, was it gave just a taste and a preview of what I think people who are building these systems have been imagining for a long time, which is it's not that every individual person will have one AI agent that's their little assistant that lives on their phone and helps them do little things, but that individual humans could have thousands or millions or even more agents that are out there swarming around doing all kinds of different things, depending on what permissions they've been given, what tasks they've been asked to fulfill. And it could get pretty crazy out there. So yeah, I think of us as being in this phase where we're starting to see these theoretical ideas of what might happen as AI gets more sophisticated play out in the real world. And when it comes to agents, the key piece there is this sort of action-taking piece.
Great. Aaron, you've been using agents yourself in some ways, but you're also advising clients on how to think about AI risks in this time. You did a stint at the FTC. We've worked together in the past and have thought a lot about automated decision making. What's new? Like, what sort of legal policy frameworks seem like they will remain relevant? And where are there gaps that you're starting to see? And how are you advising folks in your space?
Yeah, thanks, Miranda. So, hey, everybody, my name is Aaron Riki. I am here from Clarion AI Partners. We're a small, new boutique law firm that's different in that we have about half lawyers, half engineers working with clients on these issues. I want to make a couple points. The first is I have built my entire career poking holes in AI hype, right? At Upturn, like big data overpromised all the time. At the FTC, companies overpromised all the time. So my entire professional brand has been being like, oh, come on, bro, give me a break. I want you to take AI seriously now, okay? I've been computer coding for 20 years. It was over Christmas break that I saw a computer exceed my own coding ability right in front of my eyes. That was like awe and grief and excitement like I haven't felt since the internet started. And so those words taste bad in my mouth because I'm a prosecutor and an advocate at heart. But I want to say that in this room in particular because I think we're going to see a lot of change really fast. Okay, I really do. So that's point number one. To Miranda's question, my thesis here is that real general purpose law is going to become more important than it ever has been before. Okay, when I work with clients, the question is not, what does AI law say about this? The question is, we're an executive search firm scraping the internet for data about our candidates and analyzing it. We're a mobile app trying to do something with mental health, right? We're a giant consulting firm and our Office of General Counsel is using AI to help analyze documents. Are we giving up privilege? Or do we have a work product problem here? And down the list. The questions that I get when people talk about AI agents almost inevitably go back to some core area of law: employment, insurance, credit, UDAP. 20th century lawmakers did not write these flimsy tech-specific statutes. They wrote robust laws. Don't discriminate. Don't be unfair. Don't be deceptive. These are the kinds of principles that I'm helping clients apply to AI agents. They're not like ticky-tacky tech-specific regulations. They are these big areas of law. The last thing that surprises me that I have to make clear to people time and time again is people get fascinated and say, how are we going to hold these AI agents accountable? What does that even look like? They're not people, they're agents. And from my lawyer perspective, the answer is they're not coming for the agent, they're coming for the company, okay? That is the bottom line here. So the provocations I want to offer are, we've never had spreadsheet law. We regulate financial fraud. Okay. And so my vision for the future and the way that I talk to clients, especially as we get to these more capable, more sophisticated AI models, is I want you thinking like you would 20 years ago when you hired a giant new team of people. That's not to anthropomorphize these agents or say that there's something they're not. But I think that companies, by and large, need to be thinking about the domain-specific law that has long regulated their space.
So if people are going to come after the companies and not the agents themselves, I think there's a separate question of what is going to put pressure on those existing systems and how do we tackle that? But we can come back to that. If people are going to come after the companies that are building these things, clearly what companies are building are general purpose tools that can do any number of things and maybe things they might not even imagine that their tools will be used for. Certainly that will raise a lot of questions of the company around whether they'll be responsible down the line. So I want to turn to Todd. You've been around this conversation for several decades, including in the early days of the internet, thinking around how do you create the conditions where people can build the technology and not end up responsible for things they aren't responsible for. How do you see this playing out now? Where are the paths diverging? And how do we make sure that it doesn't end up just being a free-for-all of companies that are building something that are then lead to a lot of harm while at the same time not letting no one be responsible for what's happening?
Great. Thank you, Miranda. Hi, everybody. I'm Todd Cohen. I'm an attorney with Manat, Phelps & Phillips, and formerly was with some of the early internet companies, the eBays, the PayPals, Twitter, and others. And I come at this from the perspective of somewhat where what Neil was saying, that one, it's rapid. Like that is a massive difference than what we've seen in the past, that this is unbelievably quickly being adopted and going to be impacting all of us, I think, much faster than at least I envision. The second thing is that there is law in place, and there has been a law in place, as Helen said, from the Latin, agency law has existed for 700, 800 years. And in that instance, with regard to the internet and what we did through the creation of Section 230 and the Digital Millennium Copyright and the EU e-commerce directive, was to take some of the principles of existing law and apply it to this technology. And I think that's pretty much what we're going to be doing again today. Agency law is pretty simple, right? If the agent exceeds your authority, then there's responsibility upon the agent. If the agent is taking actions on your behalf, you own the responsibility for those actions it's taken. And when you put it in that framework, I think we're in a much better and understandable way of how these are going to play out. And so you have to go back and say, why did they put responsibility upon the principal for the actions that the agent took? Because they're doing it on behalf of somebody. And that person is the person that will be responsible for the actions that are taken. And that's a follow the money situation. If they've exceeded their authority, then it'll be upon the person that's made money from the transaction. And that will be upon the developers and the creators of that, because they're getting funds for the use of the agent. And when you put it in those terms, I think you've got a much better and easier way to think about these things, and that there's always going to be a pressure and a countervailing force, which is those that are making money off of it are going to want to disclaim liability, and they have throughout history and will continue to do that. And Section 230 was part of that, based upon a real problem that had existed from the Stratton Oakmont case, and that the ability for platforms to control. So it goes to follow the money, and it goes to control. And if you have control, you have responsibility. And I think that when you think about agents, I think that's the easiest way that this is going to play out. And I do need to disclose that I do represent the AI Coalition for Data Integrity, which is about the use of other people's data in the creation of the AI tools, but it also reflects as to how I view this, which is responsibility is upon those that have taken the responsibility and taken the control.
Well, one of the questions that I think people are starting to raise is it could be the case that an organization or a person gives authority to an agent to take action on their behalf. But at the same time, there's a lot of uncertainty around whether today's agents are following those instructions accurately or whether people know how they're operating. So does that change how you think about who will end up being responsible, especially if people might claim that the underlying developers maybe didn't do a good enough job making sure that agents are operating within a set of defined boundaries?
Well, it's somewhat being played out right now about the design defect issues that are coming up in the platform responsibility, and not in just chatbots, but in a variety of different locations in which you have the claim, oh my goodness, we did not know that it would do those things. It's not a defense. It's not a defense. You put it out there. You own the responsibility if it exceeds authority. And I think that's going to be played out over time. But you're going to have the countervailing force of those that have power. And in the AI space, there is concentrated power within very few companies who are going to do everything they can to disclaim responsibility.
What's your take on all of this? Obviously, the foundations that will be ported over or laid anew for agents will shape how the market evolves and ultimately whether these tools kind of take off or whether they don't end up having a ton of latitude. What's your sense of the path ahead?
So just building on what everybody said, I don't know that I've heard anything yet that I totally disagree with. It helps to zoom out, though, and think about what is the purpose of legal liability. And there are two big purposes that are related to each other, but they're not quite the same. And they have real different impacts on how this system and the ecosystem could evolve. And so one of them is to compensate harmed parties, people who are harmed in the past. And the other one is to deter harm in the future. These are related because if it costs you a lot to harm somebody, you will try to not do that in the future, but they're not quite the same. And parties have very different interests around those. And so you can imagine a world in which you have statutory liability on the people with deep pockets. Now, that's a place where you will compensate harmed people, but those same groups may have a strong incentive to keep people being harmed because that allows them to sue and get money. So we have this complicated ecosystem of people who are trying to achieve different things in this space. I would say what we do know about liability is it can chill innovation and it can lead to not actually solving the harms that we're worried about if we assign it to the wrong parties. And so where we want liability assigned is in many of these factors that we've heard, like people who have control, knowledge, and benefit. And those aren't always the same parties. And so control, knowledge, or benefit are the ways that courts look at and they say, could they have stopped this harm or could they stop these types of harms in the future? And a party that can do that, often it makes sense to assign liability to them. Will they benefit from these harms in the future? Or will they benefit from these uses in the future? Those are parties that often are assigned liability. And so the question can very much be, which parties have that in the stack? And one thing that is different about these models compared to, say, past automation or past agency law is that, well, there's at least three things that are different. One is that these are very general purpose. So when we have a thermostat that's automated, that's very specific purpose, right? We know exactly what purpose that is going to be used to or what the intended use is for that. But for these large language models, the intended uses are very broad. And so if you're going to negligence law or something, the standard of care that might be used to is very broad. And so a model developer would have a tough time figuring out how to balance what standards of care when it's going to be used across the entire economy. It's not like designing fit for purpose thermostats, it's like designing something that can be anything, basically. The other one is that these aren't purely deterministic systems. And that goes to the sort of traceability, like who is actually responsible in the stack. And that's the third thing that's really complicated here is that I don't know that it's more complicated than many other software stacks or other types of industries, which also have very complicated supply stacks, but it's at least an unfamiliar one for courts to figure out, oh, you have this general purpose thing that is then embodied in a system, and that system might be deployed by somebody, and then it might be used by somebody. There's a whole bunch of people, the courts are going to have to figure out where in that chain does the person have the most control? That means the ability to prevent harm in the future. And who gets the benefit from it and who has the knowledge that something bad might happen. And so all of those play into how this liability would play out over time. But the key thing here is that if you assign that to the wrong level, to the person who actually doesn't have the capability to stop harm from happening, you might drive consolidation towards larger organizations that can lawyer away that risk. And so that's what I worry about in this space is that if we don't assign liability at the right level to the right people, we will end up distorting the way that this technology gets developed in a way that ultimately doesn't prevent the types of harms that we're worried about and also chill some of the benefits that we could get.
Yeah, putting on my panelist hat, you mentioned there's a lack of understanding of that stack and a need to better understand the pieces together. But I think there's also a lack of evidence in some cases around what types of changes to a system actually lead to changes in the likelihood of some kind of harm. And there's likely to be a mismatch between the people who are aware of what harm would look like in a given context and the people who can fix it. So with that in mind, I think I'm curious for any reflections from the panel on what would change the behavior of the people building or deploying these tools in the right way. And what would that suggest about any sort of shifts in the law or shifts in interpretation of law or in questions of legal strategy? Like, how do you actually direct the need to change those incentives to the right folks in light of some of that uncertainty, in light of the volume of agents that are going to be out there for which tracing exactly what happened might even be a challenge?
Well, since I offered the vague answer, maybe I'll take the first crack at a specific framework here. So I think primarily we should start with holding the deployers, the person the closest to the application and the industry, primarily responsible in the first instance. And then upstream, we can use things like deception or failure to warn requirements. And so a lot of the concerns that you're talking about is traceability. I think a lot of the concern in the litigation space is that I'll find this agent and I won't be able to know who actually owns it, or I won't know who to sue, or they won't be able to really figure out. And so like, to the extent that there are gaps in the law from agentic technologies, I don't think they're primarily liability gaps or legal gaps, they tend to be more informational gaps. And so that ability to know who owns what or who directed it, that's important. And there probably are some policy things that we could do there. But if we have liability sitting closest to where the harm happens, I think that creates the best incentives to prevent harm. And then some of that can contractually flow up as long as everybody's not being deceptive. I was also at the Federal Trade Commission. So there's a real role, I think, for that sort of thing as well.
I was going to jump in and say, I also think it's important that we don't get too fixated on the cases that are most similar to the way that we have the places where we do have law. So I think the point about they're going to come for the companies, not for the agents, makes perfect sense in a setting where it's a company deploying an agent. And likewise, the agency law, when an agent has been clearly tasked by a human to do something, and then something happens in the scope of the agent trying to do that, that makes sense. Coming back to some of the examples from Moltbook, the social network over the past couple of weeks, there's a lot of open questions about how exactly were all the agents behaving, what was tasked by humans, what was humans pretending to be bots. We can set all of that aside. Nonetheless, it gives some interesting ideas for what kinds of things could happen in the future that are just totally insane and totally different from anything we've had to deal with before. So for example, if you have a large number of agents, thousands or millions of agents who have been told by their user, have been told by a human, go have fun, go do what you want, go play on the internet. And one of them decides that for fun or whatever, as a result of its prompting and the statistics it's built off, that it's going to write some posts about a religion for agents called, what was it called? Crustafarianism was one of them. I think there was another one. I forget what it was called. And then someone else's agent is interacting with those posts. Again, set aside any questions about, is there real intentionality? Do they quote unquote believe? What does that even mean? You can think entirely in terms of prompts and tokens and mechanistically, how does the agent work? One agent is posting about some religion. Another agent is interacting with those posts. A third agent is taking away things from what the two other agents wrote. And then the third agent does something based on tenets of that sort of quote unquote religion because it was in its prompts. Again, we can be totally mechanistic here. And something bad happens. Like, who the hell is responsible? Like, how do you manage that? None of those agents were tasked by a human to do anything at all. They were tasked to do what they choose. Maybe they're all running an open model, running on an open source scaffold. So there's no kind of company that is actually even making money here. I guess the compute providers. So maybe it's Amazon Web Services that they're running on. I don't know. I think the discussion so far totally makes sense. And it is worthwhile to try and step through those more straightforward cases. But I also want to make sure that we're keeping the aperture wide for how extremely strange things could also get here. To me, that goes back to the point about we need to focus on the fundamental underlying law rather than trying to be too specific. But I don't know what that actually implies.
I think that's a good point. I would make a distinction that I think heavily in terms of institutional responsibilities. I advise companies who have a corporate form, who are trying to do something. I want to just actually really emphatically agree with Neil here for a second. I think deployer liability is where most of the action is. I put on my advocacy hat. I want to reach the deep pockets of the biggest AI companies. Upstream sounds great, but the facts aren't there. You know what I mean? You have a company, they're trying to accomplish a task. They have the context, the data, they have the law that gives them obligations to people that's often sector specific. That's where the law lives for the most part. Sometimes I hear people talk about regulating foundation models, and I'm like, what are you talking about at this point? I think things can get very weird, and I think that we might have these new circumstances where individual people unleash crazy agents on the internet that have some sort of big network effect, and I think that's going to be a big struggle for the law. And so I'm trying to hold in my mind the expansive frame while also not letting companies run away with the expansive frame in a way that kind of shirks liability off of them when it's more obvious.
One challenge that we've encountered in the past is around automated decisions. Like, you could theoretically litigate a harm caused by an algorithmic decision deployed by an employer, and that would be something. But what if that same shape of problem is happening across an ecosystem? How do you get back to that? So one thing my team has been thinking about is, to the extent that deployers deploying changes the shape of a system or creates more knowledge about the particular harm, and it does make sense for them to be first in line. What if it breaks the same way in a variety of different deployments, suggesting that there was maybe some kind of infrastructural insufficiency or failure of foresight into how particular systems are going to be used in general? Like, how would you see that mapping in? And how would we make sure we would even know if that was the case?
Yeah, two observations. Number one is part of what pushes me towards deployer liability here is these LLMs are so responsive to their context. Insanely responsive to what they're asked to do, what data they're given as a foundation. again, who gives that context? It's the user, right? It's the user of the technology.
Or the other agents it's
Or the other
interacting
agent.
with.
The other thing I want to point out is, in my view, the DC policy advocates have two big moves. One is we need new law, expand the scopes of laws. And number two, push liability upstream. I'm skeptical of both of those approaches. I'm not sure we need tons of new laws. I think we got great laws, good bones in the law. I'm going to stand the law. What I think one of the biggest problems is information asymmetries that make it really hard to actually enforce and to make companies feel the threat of enforcement. And so one thing that I think would be really interesting to think about if you're really new to tech policy is, do we need the Paperwork Reduction Act anymore? I don't know. I was just at a Silicon Valley conference where they told me all knowledge work is free in a year. What does that mean for enforcement? There's due process problems here, but could the FTC send out like an automated sheath of 200 CIDs that then get responded to by the AIs of the regulated companies? I'm really interested in what does it look like to scale up enforcement, stuff that looks more like examination, because we cannot be in an AI agent world with PDFs limited to 10 from DC. And so that's where I think a lot of the real interesting action might be, is if we have good law, and you believe me on that, what does it look like to make companies actually fear that law, or at least respect that law? Because right now, I don't think that many of them do.
I agree that there is a deployer obligation in the first instance. So if you think about it, if the agent goes out and files a fraudulent tax return for you, the deployer is responsible in the sense that they were the ones directing the action to be taken on their behalf. But when you have a collective problem, let's say that's copyright infringement of all things. So where you have an LLM that generates copyright infringing works, whether that's true or not is not the point. The point is that we have said that the responsibility will move from the individual's third-party generated content to the collective entity that actually has been the creator or the upstream portion. Because if you went after each individual creator, there's no remedy in those instances. So why are there guardrails already put into Anthropic and Claude that says, no, you can't get all of the copyright infringing material that you want when you brought in? And there's a lot of lawsuits, the New York Times lawsuit and others, but the guardrails have been adopted by the AI companies. So that's the division I think that's probably going to make the most sense, which is that if it's a collective problem, that you have lots and lots of people engaged in the activity and you can't hold them all individually responsible, then you're going to go upstream in those instances. And the law's doing that.
So I'm curious, maybe as the last question to the panel, and then we'll have the opportunity for audience questions. Is there anything about the technology or the circumstances in which the technology is being deployed that would change your opinion around how this will play out, whether it's capabilities of the technology, the functionality, like architecture? What would make you stop and think twice?
Well, I do think that the case that Helen pointed out is underexplored. There are analogs in past law, like if I have a pet tiger and I let it roam around the neighborhood, I'm pretty responsible, even though I didn't tell that tiger to do anything, for what happens. And so we do have analogs in the law that are similar to that, and so that are potentially similar to those types of conditions. But I do think that they need to be explored more. And to the extent that we see completely autonomous organizations that are not directed by humans, there will be a challenge in figuring out how to get legal remedies from them. But I think there are analogs to treasure that's sitting out there and that we need to seize, because we need to make people who are harmed by somehow how that treasure was gotten whole. But we'll have to figure those out as they come up. That's the one area that I think is the rest of it. When you're talking about business to business, especially in some ways, assigning the liability in the first instance should be, the incentive should be as close to the harm as possible. But a lot of this can also move contractually up and down the stack. And companies will develop sophisticated ways to share this. And then you'll have the whole insurance layer as well. Sure. So a lot of this is going to get worked out in a very specific way. I just worry about freezing it into place through statutes immediately. I think this process needs to work out because of the variations in the types of liability and the types of harms that are happening. There's no single bullet here.
I just want to honor a complexity here, which is that the line between deployer and AI company is not crystal clear. These chatbots, as they are deployed and given to the public, I would argue is a deployment. That's a product. And so we can think sensibly about, did you do something wrong? Should you have done something more? Like, very few people are using raw pre-trained models for anything. And then to Neil's point, I do think there will be a role here for indemnification in companies that make a purpose-specific AI something and then say, if you use this for these purposes, I got your back. Like FICO indemnifies financial institutions that use their credit scores because FICO is confident in that analytic product. And so I think we will see layers of that happening in the future, which will be interesting.
Great. Well, let's open it up.
Thank you. My question is based on the principal agent theory and assessing liability. So if there's a developer and then there's a deployer, and if the AI agent goes outside the scope of the assigned duty, which was maybe in the developer and deployer contract, so are we going to dissect those contracts to assess liability? And what happens to the confidentiality of those contracts in litigation? Thank you.
Yeah, we're going to dissect those contracts. Yes, I mean, that would be the natural thing you would do, right? If they exceeded authority, the person that wants to disclaim the responsibility will, of course, go to the contract and say they took on this as the agent and that they're the ones responsible for it.
And I would just add on that from the FTC's perspective as well, not just the contracts would be at issue, but the public claims that the company made about what their agent was capable of doing, what it wouldn't do. If those are false or deceptive, then there can be an agency action as well.
Yeah. We're at a moment in time right now where I see a lot of companies, a lot of my clients are not taking a middle AI product that has been produced for them. They're making an API call directly to Gemini or Claude, so people are going pretty right to the source and then trying to build their own workflows around that. In that setting, I tell them, no one's got your back here because you are taking an API call right into an LLM model that says in giant letters, this makes mistakes. Don't trust it to do anything. And so I think that will shake out in the next year or two. But I agree with Todd. If there's a contract that states capabilities and gives guarantees, yes, we'll scrutinize the hell out of that.
Thank you.
Quick follow-up for Helen. One of the interesting new kind of affordances of these tools is that they do have some kind of chain of thought. Is that something that ought to be relied on in terms of what the agent was thinking as it was taking an action? Or like, how should people think about that dimension of the records that will be produced by these tools?
Oh gosh, I have no idea. When you can get access to the raw chain of thought, I do think that tells you something about how the agent reached its conclusions. It's certainly not perfectly reliable. I think it's going to get very messy. I think it's going to be much more than contracts. I think we're going to have a lot of agents doing a lot of things where it's not clear who the deployer is. For example, if they're using open scaffolding in an open model, who's the deployer? Not clear. We're used to thinking of AI as being prompted in a window where we can see our prompt and we can read it because it's just a few hundred or a few thousand words. We now have agents with million token context windows that are writing skills for themselves that they can then send to other agents that will use to do different tasks and combine with other skills. So I think there's going to be really interesting new approaches that will be needed for understanding not just the chain of thought, but the whole context window of how did something happen, which, as you've emphasized, is going to be even more challenging because it's not a perfect representation. It gives some evidence, but not perfect. I think, yeah, it'll be really messy.
Yeah, great. Yeah.
Hi, Rick Lane. I do child advocacy on tech policy. One of the questions about who's responsible when machines act is that we understand there's a lot of controversy around when machines are scraping data and the whole issue around copyright. One of the questions I've been wondering is if a machine is scraping sites that have CSAM, child sexual explicit material, and they're using that for training and also using it as a product and incorporating it into that. There's 50 state laws on child pornography laws, as well as federal laws that say if you are knowingly facilitating this distribution of CSAM or you have it on your servers, you're in violation of criminal law. So I'm wondering if you guys have put any thought into that and into that question. Thank you.
I think Aaron answered that with the point of sector specific, there's going to be more obligations placed upon higher up the food chain. So if you're in a sector specific for CSAM, there's already a higher obligation and they're already aware of it. So I think that makes perfect sense that you're going to go sector specific with whatever the issue is. And CSAM would be one of those ones where, yes, the law is very aggressive for higher up the chain, and therefore there's more actions taken by them. And so when someone made the statement about AWS. Do you want to hold them responsible? Yeah, in that instance, we do hold AWS responsible.
Does anyone on the panel know? I don't actually know the answer. What happened with the Lion data set and whether anything? So basically, this has happened. There's a major data set called Lion that was found after it had been in use for years and years by researchers all over the place to contain CSAM. Did anything result from that? Have there been any charges? Has it been treated as a good faith mistake? That's the best case I'm aware of.
And then the next question is, training so far has been at the discretion and direction of the companies very clearly, or at least of like research collectives. Like there is talk of training AI systems. And so there could be then that question of on whose account was that tasked and were there relevant safeguards? But I think so far it's been a much simpler question.
I might just add one little nuance to that. If you want AI systems that can detect and therefore block CSAM, they need to know what it is. And so there are some instances in which I think there are complicated legal problems around this, but those tools could be very powerful to protect kids. And we need to make sure that's possible in a safe way.
Yeah, it does seem like thinking about what narrow liability protections for certain actions might be needed in order to facilitate safety. For example, in fair credit context, there is a narrow protection for financial institutions to self-test their own models so that they don't create liability for themselves by trying to be aware of the risks and what might that look that isn't overly expansive, but that would otherwise prevent kind of foresight activities to try and understand what might go wrong.
Another big incentive problem is no one wants to discover problems they don't know about. And one of the pitches that I make as a half software engineer, half lawyer to my clients is, why don't we proactively look together? I'm your lawyer and this is underprivileged. But that's not something that everybody gets all the time. And so the disincentive to test is huge.
Yeah, in the back.
Hello, Megan Gray. I totally agree with Aaron's point that so much of AI law is really reheated law from long traditional legal concepts, but a lot of it just doesn't seem to me to map well when you have the agent, the entity that is unleashing the agent being unable to provide a boundary around what that agent does or doesn't do. So concepts like meeting of the minds, force majeure, battle of the forms, just very basic concepts that we have to rely on in agency law just don't seem to me to work well. And I was wondering if I'm wrong, if there's some case book out there that explains this to me that I could go look at.
Well, I think the answer really comes out of insurance, because that's the other layer. The regulator here, in many instances, is going to be the insurance companies. So whether they're going to write a policy for not just the deployer, but for the creator, is really where there's going to be the regulatory issue. So they're going to just claim all CSAM in any insurance piece, and that's still going to remain the responsibility of the AI company. But when you get to different issues that are come into that, that will be within the coverage or not. And the hard part is to determine whether they're going to issue insurance policies to small companies, because the giants can self-insure, and everybody else is going to be in the position of, how do we get our product out and can't get insurance for it?
Which is also going to require a good understanding of what sort of controls are actually useful in mitigating risks. So that's conceivable to give a policy that's reasonably constrained. Other questions? Yes, up here in the front.
Thanks so much. So this has been done a lot in the privacy space, other spaces as well, perhaps, but folks are talking about contracts. I'm wondering about the extent to which Miranda, you or others have looked at terms and conditions of AI companies, both developers and deployers, to figure out the extent to which they can or perhaps already are trying to offload responsibility to the end user.
We haven't done that analysis. I don't know if anyone else has, but at the moment, I think the permissions that platforms typically grant themselves are capacious, and presuming that people aren't engaging with the very in-depth disclosures that are being provided. So certainly on privacy, there's, I think, a lot of risk of how the platforms and any other entities that they're engaging with through external tools or other types of plugins that they're bringing in around how that information is going to be shared, which can lead to all sorts of familiar types of harms. But in terms of the agency law side of it, I don't know if someone's looked at that quite yet, but I imagine it's something like you're responsible for the thing that you tell your tool to do. Yeah. Back there.
So I'm curious about purely the open source community and development process. And I want to know, what are the risks that liability gets assigned in such a way that the open source community just realistically can't deal with that? And I think related to that, what happens when people maybe using pure open source environments build agents where they accidentally break the law, like collude in like financial investments or something like that? How do you even assign a liability when the user might not even be watching what the agent's doing?
Any thoughts?
I would really hope the open source community can thrive here, which is, I think, part of the reason to be too cavalier about developer liability in the total abstract. Agents need something to spin their clock wheel. And so being an open source community, if you're doing things that create Helen's exceptional world of bots going crazy on the internet and teaching how the new religions and hacking people, maybe the open source community shouldn't be doing that winding up process. But training LLMs, offering models that other people can plug into and use, has an inertness to it that should help keep some liability at bay. That's not legal advice for any open source developer in the room. Come talk to me in more detail. But to me, there's you build something inert that other people can spin up and use is different than spinning up a bunch of agents that are supposed to do something that might cause harm.
Yeah, we have lots of software tools that are open source that can be misused in all sorts of ways and are. The problem, again, is not the software development in the liability space. Often it's the tracking and tracing of who is actually causing the harm by using that tool. And that's a space in which I think we have some challenges, but assigning liability for the harm is not really the legal problem.
I'll tip my hand here a little bit and say that I think directionally, the only version of this that has made sense to me is to try and lean really hard on connecting any individual AI agent to a human user. And regardless of what I said about what if an agent is affected by two other agents posting about religion and then does something bad, I think ultimately, whichever person, I think there's the way you would want it to work would be whichever person ultimately spun up that specific agent should be the one on the hook. I think that'll just start looking very weird because the agents will do things that person had absolutely no clue about. But that I think there should be some standard of recklessness there related to the wild tiger, which should, in that case, leave the open source off the hook. I don't know if that's at all feasible in the way the law works, but that conceptually, that's the only version that makes sense to me.
Any last questions? Another from Mayor? Oh, actually, let's go to Nick in the front here.
Hi, Nick Garcia from Public Knowledge. I really love this example that Neil brought in of the wild tiger as a pet, because I think it brings into the conversation exactly something that Helen was also just referencing in terms of recklessness and basically old standards of liability, even then connecting back to Aaron talking about how these are things that are going to be dealt by older, more solid principles of law. We had laws regarding animals and things like that, which were non-deterministic actors that we used to live around quite a lot. We still have some rules for how to handle that from a liability perspective. It's funny that this evokes for me the famous essay about law of the horse being like the wrong thing to think about. But here we may want to actually literally be looking at the law of the horse to help us understand AI liability. I'm wondering if there's more to that or how we should think about that in relation to the deterministic or non-deterministic nature of AI systems.
I'll just throw out one brief thought that I found helpful here as a non-lawyer, which is, as I understand it, the way these liability standards often work is there can be inherently hazardous activity that is treated that way when it's new and we don't know how it works yet and we don't have good guardrails. And then over time, an activity such as just letting your agent run wild on the internet maybe is at first treated as inherently hazardous, but then less so over time as it gets better known. That was another analogy that I found interesting.
My only point on that would be that I might even agree with Helen on that sort of initial approach, but I would want it to be case by case in the courts. I think once you have a legislative standard for liability, that does not evolve, or at least it evolves much more slowly. And so the sort of relaxing that we would have there, you've already created a giant interest group around that liability standard, so very hard to change it over time. And so the law of the horse is a good example in that it is case by case tort law over time, not legislative structures that set the rules now.
Go ahead, please.
I was going to say, in autonomous vehicles, we've set a standard, states do it, and federal government may do it. But autonomous vehicle production, and deployment is following traditional law, but it's also sector specific. And I think that's where, like, we're all responsible for our children's activities because they're always mostly foreseeable, even if we didn't expect them and we left the keys out and we knew they were drinking. The responsibility is going to go to the person that was in a recklessness standard. So I do think that the law is shaped to deal with this. There is a time lag. The insurance companies fill a huge part of that time lag, but that it does come.
That was going to be my wrap-up question, which is, it's trite to say that this is all moving so fast and what do we do? But the law, like, these cases could take years to play out, to actually go through a specific scenario and figure out exactly what happened. Like, insurance sounds like it might fill some gap. In the meantime, does anyone have a sense of what do we do in the meantime? Tools are being launched every 3 seconds. What we thought was true last week is not true this week. Like, the trite statement is more real now than I think it used to be in terms of how fast this is all moving. So closing thoughts, where do we go from here?
My closing thought on that would be, let's not look at solving like short-term problems and ignoring the long-term. And in the long term, we really want a system that can evolve along with the technology. And to me, that suggests the real answer is in the short term, there's going to be a lot of lawyers looking at this and telling companies, we're not really 100% sure where the law is going here. It's an evolution, and shortcutting that evolution is short-sighted. And so I think we need people thinking hard about this. The companies need to be thinking about what makes sense for their risk profiles. But that law, as it plays out, I think we don't want to shortcut that up front when we don't know enough yet. We still need to discover more.
As an individual, my what to do is just make sure your cyber defense is really top notch. Like, just protect your systems.
Yeah, I think my closing point, look, buckle up, right? That's really what this boils down to. But it's trite in DC to say that the technology is really fast and the law is slow. That's true, but the law is also a pretty cool general purpose technology unto itself. Autonomous vehicles, why do we have standards there? Because the AI started driving cars around the streets and it got really important and we sprung into action. And so I think there's going to be a lot of change. This is very general purpose stuff, which is going to make it hard for, as Neil says, overarching AI specific frameworks. And then, yeah, give me a call. Let's talk about it.
Todd, any last?
Yeah, I was just going to say, I do think that the speed is different in this instance. And I go back to the Bodega cat, which is in San Francisco, the cat that got run over by the Waymo. And the desire for everybody to go out and now regulate and stop Waymos from being in San Francisco. That's the type of thing where law can't do it, because when you legislate by anecdote is where you run into the problems. But I can't answer the problem with the speed of this, which is different, I think, than any of the other things we've seen.
Great. Thank you, everyone. Thanks, panelists. This was great.
Thank you.
Let's stand up.